Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national document service. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have an extremely important webinar that a step-by-step guide to get paid after you record a lien. So without further ado, I introduce the fabulous Alex Barthet.
Thanks, Ariella. My name is Alex Barthet. I am a board-certified construction attorney here in South Florida. And today we're going to talk about each step in the process to get you paid after you record your lien. So let's dive right in. So on today's agenda, we're going to talk about what a lien is and how it works. We're going to talk about what happens after you record the lien and some misconceptions that many contractors believe occurs when you record a lien. Then we'll talk about the process of how to get paid, each step in the process so that you can get paid. We'll talk about some scenarios, most common scenarios that you may run into. One is if your lien is bonded off. Two is what if the other side sends a notice of contest of lien. And three, what happens if you receive a 20-day summons? These are three common things that may occur after you record the lien. We'll talk about each one and how to deal with it. And of course, as we do in each of these presentations, if you have any questions, please ask them. With respect to your questions, use the GoToWebinar chat box on your computer screen. We'll take all the questions at the end and answer them. Please make sure not to include the names of any people or companies in your questions. All right, so let's talk about what is a lien. It is an encumbrance on real property. It attaches to the real property based on a legal right that you have as a contractor, based on the fact that when you provide improvements, permanent improvements to the property, the law gives you a right to sell that property in order to satisfy the debt. It creates what's called a cloud on the title, and it can prevent the sale of the property or the refinancing or mortgaging of the property when your lien is there. Under most mortgages or loan documents, having a lien on your property, even if that lien is recorded after the mortgage is recorded, typically constitutes a default, usually a technical default under most mortgages. What does that mean? That means that if the lender were to find out about the lien, they would probably start by sending a letter to the owner saying, hey, you have this lien, it constitutes a default, please take care of it. And at the discretion of the lender, they may decide to be a little more insistent on the resolution of the lien. During the course of construction, and this is really where we see a lot of the pressure brought to bear with a lien, it typically constitutes a default under the prime construction contract. And it will prevent the lender, owner, or contractor from funding. So for example, if you're an electrician and your electrical supply house records a lien on the project, that lien during the course of construction will likely prevent the owner or lender from funding the contractor and thereby prevent the contractor from funding you, the electrician, because that lien is there. So it creates a whole bunch of problems on the project as the project is ongoing. So what happens after you record the lien? In short, nothing happens. So the first misconception that we hear from clients on a regular basis is that well, you know, the clerk is going to check my lien to make sure it's accurate. That's not true. The lien is a document that's prepared by the lienor or a service like SunRay or an attorney, and the clerk does not review it as long as it's a document that meets the minimum requirements and has a notarization on it, meaning it's sworn to. The clerk will record it. I could right now, if I wanted to, prepare a lien and record it on any one of your projects. I've never been there. I've never done any work on your projects. That doesn't stop me from recording it. It will not prevent the clerk from taking that lien and recording it in the public records. And now you'll have to deal with it. So just know that there's no gatekeeper at the clerk's office preventing liens from being recorded. So if you are, for example, a contractor and one of your subs or one of their suppliers records a lien and they never had a right to do it, maybe they never sent a notice to owner, maybe they didn't deliver the product that they were supposed to, no one's going to check that to prevent the lien from being recorded. Unless the lien bothers the owner or the contractor enough to pay you, it's not going to cause you to be paid. The lien is not a self-executing document. This is another misconception we hear from our clients. Well, I recorded a lien, so they have to pay me. Technically, they don't. They could just let the lien sit on in the public records until it expires, and it expires 1 year from the recording date of the claim of lien. There are ways for it to be shortened, and we'll talk about those. But if it doesn't bother the owner, nothing happens. So a classic example is, let's say you're a roofer, you do work on a residential homeowner's house, there's no mortgage on the property, they don't pay you $10,000, so you record a lien. And you think, well, because I've recorded the lien, now the owner's got to pay me. No, the owner could just let the lien sit there and do nothing. And in a year, that lien will expire automatically. It cannot be renewed. There's no such thing as recording a new lien after the first lien expires. So just know that it's up to you to enforce your rights with respect to this lien. So that leads to the question, how do I get paid? What are the steps I need to follow in order to get paid once I record my lien? So as I mentioned before, the lien only starts the process. It creates a legal right that you have in the property to sell that property at a foreclosure sale in order to get paid, but it is only the beginning. So let's talk about this foreclosure process. The foreclosure process is just a legal action. It is no different than any other civil court case that needs to be filed. So substantively, it's not any different than a real estate transaction that went bad, or a divorce, or a slip and fall. A lawyer needs to file a lawsuit in the court system asking the property to be sold at public auction. That's what a foreclosure action is. It is also similar to any other court action in its cost and time. So most court cases take between 12 to 24 months to move through the court system to their completion at a trial. But that being said, in our office at any given time, we have about 500 cases, and most cases settle anywhere from 3 to 9 months after the case is brought. And the settlement occurs when the parties come together and decide that they're willing to make a deal in order to resolve the dispute, stop paying legal fees, and move on. Some cases continue for years. We have cases in our office that are 5 years old, and they've been actively litigated those entire 5 years. So just be aware that a foreclosure action is no different, nothing special. What is different about it is that the end result is the sale of the property. As I told you, you have 1 year from the recording date to file that lawsuit to foreclose on the lien. If you don't file that lawsuit within that 1 year period, the lien automatically expires and you cannot re-record the lien. The only way to keep your lien alive when you get close to that 1 year is to file the lawsuit to foreclose. But you don't have to wait till the 1 year in order to start the process. So that's why I say that you should practice what I call the 60-60 rule. So no later than 60 days from your last work, you need to start the process to record the lien. You have 90 days from last work, calendar days, to record the lien. Do not wait till day 84, 85, 88 to start the process. It takes time, effort, and coordination. The lien is a somewhat complicated document. It has many fields that need to be completed. Maybe you need to get that information from other folks on your team. Maybe they're not available on the day you need them. The clerk's office is getting better, but there have been times, especially during the recent past, when, for example, the Miami-Dade County clerk was taking 7 full days to record a document. So you don't want to be submitting your lien on the 88th day and having it sit in the queue for 7 days in the clerk's office. Most clerks now are open for in-person recording, so that usually will speed things up. Usually, if you are willing to wait in line, you can get a document recorded the same day. SunRay uses an electronic filing system, so they can record your documents anywhere in the state electronically. But again, it's not like Amazon where they get it done right away. Some clerks take several days to record that document, even if it's purely electronic. So you've now recorded your lien, and you've started that process no later than 60 days from your last work. What do you do next? I recommend for the next 60 days, hassle your customer and the owner for payment. Send emails, text messages, phone calls, go visit people at their office, sit in their office, wait to see them to pick up your check. Do whatever it is you have to do to try to get paid over the next 60 days. Our most successful clients at collection use this 60 days aggressively. They're making phone calls once a week, several times a week, followed up with emails, visiting the customer. The squeaky wheel gets the grease. Collections is a process in which you need to be very active if you want it to work. If you ignore the debtor, they will ignore you because they are busy dealing with other problems. So you need to be the problem they have to deal with. So you should do that for the next 60 days. However, if after 60 days you have not made any meaningful progress on getting paid, then I strongly recommend at that point then you submit the claim to a construction lawyer for collection, who will typically start with a demand letter on their letterhead to the customer and then start that foreclosure process if the letter doesn't work. So except for some business reasons that you may have, and we'll talk about those right now, I would not delay past the 60-60 rule. Your legal case is not going to get any better because you decide to wait. People may leave your company, witnesses may take other jobs in other jurisdictions, they get fired, documents get destroyed, people's cell phones fall into the toilet and their text messages that get deleted. All of that happens the more time passes. So you do not want to continue to wait if you cannot get paid. Now, maybe this is a customer, a client of yours, where they owe you $5,000 on this project and you have 4 other projects going on and everything's fine. So you decide, you know what? I'm not going to let this small claim affect my relationship. I'm just going to let it sit and let's see what happens over the next few months. That's a perfectly valid reason to wait. But unless you have some articulable reason that you want to wait, you should not continue to delay your collection efforts. So that's generally the process to get paid once you record the lien. But let's talk about some of the things, some of the speed bumps that may get thrown at you, 3 of them in particular, and how to deal with them. So 1, your lien gets bonded off. What does that mean? How does it work? And what should you do? In my opinion, you should celebrate. The reason you should celebrate is that in a foreclosure sale, you only are able to recover the equity in the property. So if you put a lien on my property for $200,000 and it's worth $1 million, but I have a million mortgage or a $900,000 mortgage, your lien is likely going to be after my mortgage, and there's not enough equity to pay you. So if you go forward with the foreclosure sale, there's not likely going to be a recovery for you. So you are underwater. However, if I bond the lien off, what does that mean? That means I have to go to the clerk's office with either a lien transfer bond that I get from a surety, or I go to the clerk with cash, and I take that lien and I set it aside off the property, either to the transfer bond or to the cash. The rough formula, it's not exact, but the rough formula is that I have to post about 150% of the claim amount in my bond. So if your lien is for, let's say, $100,000, I'm going to have to come up with $150,000 of a transfer bond or cash and bring that to the clerk. So that means now there's a segregated set of money sitting there protecting my lien. So even if there's a big mortgage, even if the property has no equity, it doesn't matter because my lien is now fully securitized and then some. The extra 50% is intended to cover interest and expected legal fees on the lien and the claim. The one thing you need to expect, though, when someone bonds off your lien is that you need to be prepared to fight. And the reason is no one in their right mind would go through that entire process if they could just pick up the phone and call you and say, how can we work this out? If that was their intention, they would have done that before they went through the time and expense of bonding off the lien. So in our experience, I've been doing this for almost 25 years. I will tell you, in every single case that a lien is bonded off, litigation is required. So if your lien gets bonded off, you should be happy that now your lien is fully securitized, but you should immediately start the litigation process. Our advice when clients come to us where their lien is bonded off is we skip the letter. We don't even send the letter. We start straight away with the lawsuit against the transfer bond and the customer, because the reason they bonded it off is they didn't want to pay. So let's start the process now. There's no sense waiting. Number two, I received a notice of contest of lien. Now what do I do? So I told you before that you need to file a lawsuit on your lien within 1 year of the recording date of the claim of lien. The exception is if you receive this document called a notice of contest of lien, you only have 60 days from the day that the clerk stamps that document to record your claim of lien. On the 61st day, your lien automatically expires unless within that time you file your lawsuit to foreclose on the lien. So if you receive a notice of contest of lien, what do? You need to hire a lawyer right away and you need to file your lawsuit to foreclose immediately. So the document is prepared and by the person that wants to contest it, brought to the clerk, and the clerk will stamp it. And it will have a stamp where the clerk says this document has been recorded and mailed on this date. That's when the 60 days run. 60 days includes every calendar day, weekdays and legal holidays, all the way through the 60 days. Do not wait until the end. This is a document, by the way, that you will get via certified mail to the address that's listed in your notice to owner. So in your notice to owner, I've used SunRay, for example. At the bottom, it says, all service of all documents shall be sent to this address. So that is your current mailing address. That's the address that they need to send it to. So that's where the certified mail will go. When you get it, then you have, again, 60 days to file your lawsuit to foreclose. And then it's automatic. On the 61st day, the lien is automatically discharged. There's nothing you can do. There's no way to revive it after the 60 days. Sometimes 60 days is too long, and owners or contractors may employ what's called a 20-day summons. So what happens if you receive a 20-day summons? Just like the 60-day notice, you need to file your lawsuit to foreclose immediately. So we talked about the rule. 1 year from recording is when you have to bring your foreclosure action. Now that's reduced to 20 days if you receive a 20-day summons. How do you know that you get a 20-day summons? Unlike the 60-day notice, which is sent to you by certified mail, the 20-day notice, the 20-day summons is actually served upon you by the sheriff or a process server. So it'll come to you like a lawsuit, because it is a lawsuit. The owner or the contractor has to file a lawsuit with the court and serve it upon you, and then on the 21st day after it has been served, your lien automatically expires. So what do you have to do? You have to file a new action to foreclose, or in that lawsuit where they sued you, you have to file a counterclaim to foreclose your lien. If you don't, your lien will automatically expire. So with that, Ariella, do we have any questions?
So far, we don't have any questions, but while people think about some questions to ask, I know that a lot of people on our webinar today, they're saying, okay, well, we have these tools, we have this lien on the property. Two things. One, you know, how do we get paid for the lien? And you know, we're already out $40,000. How do we get paid? You know, if we have to have an attorney prepare the lien or have collection costs, is that something that they can have as part of their collection fees and attorney's costs, so that when they lien properties, they get that money back?
Sure. So the way it works is that at the discretion of the court, once you file your lawsuit and you prevail, Chapter 713, which is the lien statute, says that the prevailing party is entitled to recover their legal fees. So again, it's still within the discretion of the court. The court could say, no, I don't think anyone won this case to get their legal fees. That doesn't happen often, but it could. But assuming the judge says, okay, subcontractor or supplier, you're the winner, you're entitled to your legal fees, the court will then have a separate mini trial on the amount of the fees. So maybe your attorney has incurred $5, $10, $15, $50,000 in legal fees. You'll have a small mini trial. Typically, it'll take a few hours in front of the judge for the judge to determine the value of those fees. So the short answer to your question, Ariella, is yes. If you prevail on your lien, much more often than not, if you go the distance, you should recover some or all of your legal fees.
Okay, great. We have a question from someone. At what point, dollar amount, does it make, okay, hold on one second. Let me just reread this. Okay, let me try to reread. What is a rough estimate cost of a foreclosure? At what point does it make sense to consider this? And I was going to ask that next. You know, here you are on a project and you are owed, you know, and I don't want to say only, but you're owed $10,000, and clients come to you and they say, hey, I'm owed $10,000. And then you go, well, the retainer is $5,000, and that can go very, very quickly. So what do you tell clients that are in that situation? I'm owed this money, and how do I get paid on that? And I think that one of the parts of that is perhaps, and the answer I'm looking for is maybe also address maybe small claims court as well.
So small claims court, we'll start with that, was just the rules were recently changed to increase the limit of the amount of the claim that you can bring from 5,000 to 8,000. And I believe there's a rule in place that will next year allow it to go up to 15,000. So that means that you can bring your own case without the need of a lawyer in small claims court. And as that number, the jurisdictional threshold increases, it'll give you better opportunities to pursue the claims yourself. I would tell you, at least with respect to small claims, we are teaching clients probably one every month or every other month, one of our clients, how to undertake the small claims process. So what we typically do is we walk through one with them. We give them all the forms. We show them how the system works. We connect them with the process server and get them set up on the electronic filing system. And then from there on out, they've designated someone in their office to handle the small claims cases themselves. Now that the jurisdictional threshold has increased, we see more and more clients wanting to do it. It makes financial sense to learn how to do it and be proficient at it so you don't have to pay a lawyer. As far as the costs associated with bringing a foreclosure action, you know, just to give you some ballparks, you're probably looking at about $1,500 to $2,000 to prepare the lawsuit, pay the filing fee, pay the process server. So that just starts the lawsuit to move forward. The other side is able to assert any defenses they want. Your work was no good. I never received the materials. We had to supplement your forces. And those defenses are really what's going to drive the total cost of the litigation. What I tell clients most often is that it's unfortunate that that's the system that we're in, but know that the debtor, the party that owes you money, has no real obligation to pay you until you force them to pay you. So many cases, as I said, settle. So usually the best way to do it is a slow escalating process. Start with a lien, actively pursue it yourself for 60 days, hire a lawyer, they'll send a letter, which is a few $100s to send a demand letter. If that doesn't work, file the lawsuit and take it one step at a time to see, you know, as you tighten the noose on the debtor, what is causing them to come to the table and make a deal. So we've had clients that they have us pursue cases for $4,000, $5,000, $6,000, and we can make it work. It doesn't work all the time, but you know, it's a numbers game. You can't look at each one by themselves. You have to say, here's all of my collections. Let me work on them in a group and see if I can monetize this debt that, but for doing something, will likely have to be written off because you've tried everything you can and you can't turn it into cash.
Very good. We have two more questions, and one thing I also would like to add that I think is very important is venue. And venue, for those who don't know it, if you're going to file a lawsuit, I think Alex can go into more detail about this, but you want to make sure that if you are going to have a lawsuit with your client, you want to make sure that it's near your county. So you could be working on a job in Orlando, and your home office is in Fort Lauderdale. So you want to be very careful in your contract where you file that lawsuit. So just that's another thing you want to be very careful with your larger contracts. So if you want to elaborate on that, and we have two more questions. And for the gentleman person who asked the question, they said thank you very much. But if you want to elaborate on that, and we have two more questions, and these will probably be our last two.
Sure. So on venue, just know that the law requires that you have to bring the action in the county where the property is located on your lien. So I may have a contract right to be paid in Ariella's example, Fort Lauderdale, but if the project is in Orlando and I have lien rights in Orlando, I have to bring the foreclosure action in Orlando. And the reason is that only the county of Orlando, I guess Orange County, has jurisdiction to enforce that lien and force the sale. So anywhere you do work that you have lien rights, that's the jurisdiction where the case is going to be brought on your lien. So tell me about the questions, Ariella. Are you there, Ariella?
Can you hear me? I'm sorry about that. If a GC has been paid by an owner and we placed a lien on the property, is the lawsuit on the owner or the GC? Do we try to get paid from the GC or owner of the property?
So we run into the situation often. And when we get it, we ask our client, do you want us to pursue the lien or both the lien and the contract? What we typically find is that our supplier clients want to pursue the lien, and they will typically leave their customer out of it if they have a working relationship with the customer. So they will pursue the lien and leave their contract action alone. But it's up to the client. It really depends on the relationship you have. So for example, if I'm a sub and I have a lien on a project and I have 3 other jobs with the same GC, maybe I don't want to sue the GC and I just want to pursue my lien. So it is not a hard and fast rule. You can do either, or you can sue either one or both. But one of the things you definitely want to do is not forego pursuing your lien. That is probably the best and fastest way to get paid. So the question typically is, do I want to just pursue my lien, or do I want to pursue my lien in my contract? The last point on that is, if you signed a contract with a GC or a sub, just know that you may have a pay when paid provision. So if I'm a subcontractor, let's say I'm the AC contractor, and I have a pay when paid provision in my contract with the GC, and I have a lien, if the GC hasn't been paid and I have a pay when paid provision in my contract, I don't actually have a right to sue him on the contract because he hasn't been paid. So I would only have a action on my lien.
Great, thank you so much, Alex.
One last question?
If we can, that'd be great. I think
Sure.
this is a wonderful question. If there's no equity in the property to pay you from the foreclosure, then what do you do?
So you have 2 choices. One, you can try to make the determination early on that there's no equity, so you don't waste your time and money foreclosing on a lien that likely will not produce any results. Or you can pursue the lien and you can get what's called a deficiency judgment. So you could get a personal money judgment against the owner of the property for any amounts that aren't recovered by the foreclosure sale. That being said, one of the things that I will tell you is most common, and that is that even if there's little or no equity, the lien by itself has a great amount of pressure to get you paid, including the foreclosure sale, the threat of the foreclosure sale. And what I mean by that is this example. Let's assume that I'm a developer, right? And I am building a rental building, and the total construction cost is $10 million, and I have a $9 million construction loan. Well, that extra $1 million, the lender is probably going to have required that I put in that equity. And let's say you have a $100,000 lien because you're the roofer and you haven't been paid. Now, maybe there's enough equity, maybe there isn't. It's kind of close, depends on, what the sale price of the property may be. But the real power is that if I, as the developer, let you take this property for your $100,000 lien, that means my $1 million worth of equity gets wiped out. So I may decide to pay you your $100,000 or make a deal with you, just not because I really want to pay you the 100, but because I don't want to lose my $1 million of equity that I've put into this property so far. So in order to save my equity, I need to make a deal with you. And this is true even when there is no equity in the property at a public sale, but I, as the developer, am trying to preserve the equity that I put in to make this whole deal happen. So much more often than not, I would tell you that even if there's no real likelihood of a successful foreclosure sale, bringing pressure on the owner through a foreclosure does go a long way at getting you paid. So that's the last question. So let's go ahead and wrap this up and talk about our next presentations. For those of you that don't know, we have a podcast that we do each week talking about these same topics, liens, bonds, contracts, and collection issues. You can find it at the lienzonepodcast.com. And SunRay and I do these webinars each month. Our next webinar is on April 12th, titled "Don't Make These Waiver and Release Mistakes." We'll talk about some common mistakes that Ariella and I see in waivers and releases and how to avoid them. And then in May, we're going to talk about 3 project documentation tips that you need to implement right away to help you get paid on your next project. You can sign up for these and all of the webinars already online for the rest of the year at notice.com/webinars. So with that, Ariella, thank you for the opportunity. And thank you everyone for participating. Have a great day.
Thank you very much. Have a wonderful day, everyone.